Okay, I think we can start now. So again, welcome as attendees to our Zoom webinar on updates on the latest regulations and procedures of PEZA and BOI with partnership with Carpo Law Associates that will tackle about on dealing with BIR LOA. Before we formally start, we have some few house rules here. Kindly change your Zoom name to your name plus your company name, and you could do that by clicking the participants icon and hovering the cursor over your name and choosing your name so that we could address you better and we will know if you are existing client or a non-client of InCorp Philippines. You may turn off your webcam during the presentation. Keep yourself muted unless speaking or engaging in conversation to reduce background noise. You could use the raise hand feature if you want to speak or ask questions once the Q&A portion had been started. Please ask your questions concisely. We will have a Q&A portion later after all the speakers finish their slides. So we will try to answer as much as questions we do. If not, you could just send it to the email. We'll try to answer it through email to save time for this event. InCorp Philippines. We, InCorp Philippines, are formerly known as Kittleson and Carpo Consulting, Inc. We are a comprehensive full suite service portfolio. We are helping foreigners in their corporations, corporate compliance, product registration and FDA, taxation, visa and immigration, recruitment, business advisory, payroll, and corporate recovery. We also have regional presence in Singapore, Indonesia, Malaysia, Hong Kong, Vietnam, India, and Australia. So if you are looking for an expansion in these countries, you could send us an email. We could help you to expand your businesses here on those offices of InCorp. And in partnership with Carpo Law that will tackle about the BIR LOA, Carpo Law Associates is a specialized corporate law firm located in BGC Taguig that assists local clients and foreign enterprise with inbound foreign investments towards doing business in the Philippines for small, medium-sized, and multinational companies. Carpo Law's practice areas also includes a corporate and commercial, corporate tax, intellectual property, real estate, labor law, litigation, and family. Okay, I think we could start with our first speaker. Our first speaker is Atty. Emmanuel Fajilan. He is the Senior Legal Counsel and Business Consultant in InCorp Philippines. He helps clients with their legal compliance needs for business registration, product registration, corporate housekeeping, due diligence, and other related concerns. Area of focus and expertise of Atty. Eman is more on incorporation, corporate compliance, and business advisory. He completed his bachelor's degree at St. Louis University with political science course and finished his law school in St. Louis University as well, and an IBP member since 2020. So I will give the floor to Atty. Eman.
Thank you, Sherwin, for the introduction. Yeah, so I'll be discussing about the Board of Investments and the Philippine Economic Zone Authority, how to register, and if there are any updates. So these are the leading investment promotions agency here in the country to entice the investors, foreigners, and domestic to invest their money here in the Philippines and to create jobs for Filipinos. So let's start with the Board of Investments. What is BOI? BOI is an attached agency of the Department of Trade and Industry, and it is the lead government agency responsible for the promotion of investments in the Philippines. Its mission is to develop globally competitive industries and generate local and foreign investments, thus increasing employment. As mentioned by Sherwin, we have been in business for 16 years already, and we have helped companies grow their business here. We were able to help around more than 2,000 companies to set up their businesses here. So we, as a company, we offer these services. InCorp Philippines and Carpo Law Associates offer these services. Application for registration under Book 1 of EO 226. Legal and compliance services, where we help clients secure their certificate of income tax holidays, certificate of qualification to import tax and duty-free spare parts and supplies, certificate of registration, next slide, please. Yeah. So let's start with the investments priority. So the Philippines, through the president, issues an investment priority plan, and based on Article 27 of said law, not later than the end of March of every year, the Board of Investment, after consultation with appropriate government agencies in the private sector, shall submit to the President an investment priority plan, provided, however, that the deadline for submission may be extended by the President. So the latest strategic investment priority plan came to effect on June 14, 2022 through Memorandum Order number 61. We will be discussing the different tiers or the different areas of priorities of the Philippine government where incentives shall be provided to the investors to the different fields of industries. So for tier 1, the SIPP of 2022 has retained the 2020 investments priority plan. So these are the fields of investment or areas of investments where the country has prioritized, has given its focus on last 2020, and the government has retained it. For 2022, these are the activities proposed to envision and promote competitive and resilient economy and fill in the gaps in the Philippines' industrial value chains and are deemed critical in promoting green ecosystems, ensuring a dependable healthcare system, achieving robust self-reliance in defense systems, and realizing modern, competitive, and resilient industrial and agricultural sectors. For Tier 3, these are the activities projected to accelerate the transformation of the economy, primarily through the application of research and development and attracting technology investments. It includes activities involving the production of equipments, parts, and services that embed new technologies, and the commercialization of research and development output. So let's start with Tier 1. So again, this is just a recapitulation of the areas of priority of the Philippine government last 2020. So these are the qualified manufacturing activities. These would cover the manufacture of industrial goods and processing of agricultural and fishery products, including halal and kosher food, into semi-finished intermediate goods for use as inputs in the production of other goods or finished products or consumer goods for final consumption. This also covers the manufacture of modular housing components and machinery and equipment, including parts and components. For Metro Manila, only modernization projects may qualify for registration. Next would be agriculture, fishery, and forestry. And next would be the strategic services such as integrated circuit design, creative industries, knowledge-based services in the domestic market, maintenance, repair, and overhaul of aircraft, charging, refueling stations for alternative energy vehicles, industrial waste treatment, telecommunications, state-of-the-art engineering, procurement, and construction, healthcare and disaster reduction management services, mass housing, infrastructure and logistics, including LGU, private and public partnerships, innovation drivers, inclusive business models, environment or climate change related projects, and energy. It would also include the export activities such as the production and manufacture of export products, services exports, and activities in support of exporters. It would also include special laws such as any business activities that would help promote the special laws, such as the industrial tree plantation, mining, but limited only to capital equipment, publication or printing of books or textbooks, refining, storage, marketing, and distribution of petroleum products. For tier 2, on the other hand, we have green ecosystems. For green ecosystems, it would cover electric vehicle assembly. Example, pure electric vehicles, plug-in hybrid electric vehicles, hybrid electric vehicles, fuel cell electric vehicles. It would also cover manufacture of electric vehicle parts, components and systems, establishment and operation of EV infrastructure, manufacture of energy efficient maritime vessels and equipment, electronic devices and circuits for smart grid and renewable energy, including wearable solar devices, bioplastics and biopolymers, renewable energy, energy efficiency and conservation projects, energy storage technologies, and integrated waste management, disposal, and recycling. For health-related activities, it covers the activities such as manufacturing in support of the vaccine self-reliance program and other health-related programs as endorsed by the Department of Health, Department of Science and Technology, or other similar agencies, medicines, active pharmaceutical ingredients, and specialty hospitals. For the defense-related activities, this would cover defense-related activities as endorsed by the Department of National Defense, Armed Forces of the Philippines, and the National Security Council. The industrial value chain gaps, on the other hand, covers activities that will address the value chain gaps in, among others, steel, textile, chemicals, green metals processing such as copper, cobalt, nickel, crude oil, refining, and lab-scale water fabrication. And lastly, food security-related activities. For Tier 3, on the other hand, this would cover research and development, highly technical manufacturing, production of innovative products and services, establishment of innovation support facilities. For research and development activities, it would include activities which adopts advanced digital production technologies of the fourth industrial revolution, such as but not limited to robotics, artificial intelligence, additive manufacturing, data analytics, digital transformative technologies, example, cloud computing services, hyperscalers, data centers, and digital infrastructure, nanotechnology, including nanoelectronics, biotechnology production, and adoption of new hybrid seeds and other Industry 4.0 technologies. Highly technical manufacturing and production of innovative products and services would likewise pertain to activities or services, but not limited to the manufacture of equipment, parts, and services, commercialization of intellectual property, and research and development products and services, aerospace, medical devices, except personal protective equipment, Internet of Things, devices and systems, including wireless sensors and devices, full-scale water fabrication, and advanced materials. The establishment and innovation of support facilities will include, but is not limited to, the R&D hubs, centers of excellence, science and technology parks, innovation incubation center, tech startups, startup enablers, incubators and accelerators, and space-related infrastructures. So let's talk about the incentives. So upon the passage of the corporate rehabilitation of the CREATE law, the government has streamlined and rationalized the grant of incentives for all the investment promotions agency. Apart from lowering the tax rates, they rationalized the grant of incentives and provided a structure or a tier level. So this is going to be, if you can just see the table here. So if the industry falls within tier 1 and it is located in the NCR, then for export market enterprises, the income tax holiday would be 4 years and 10% enhanced deduction or special corporate income tax. If it is in metropolitan area or areas contiguous and adjacent to NCR, the income tax holidays will be for 5 years and same. the 10 years in enhanced deduction and special corporate income tax. In all other areas, it's 6 years income tax holidays plus 10 enhanced deduction and special corporate income tax. As you can see, there is the thrust of the government is to bring out the job opportunities to outside of Metro Manila. So the income tax holiday granted to industries relocating or locating in areas outside Metro Manila is longer. For tier 2, on the other hand, the income tax holidays would be 5 years and 10% enhanced deduction and special corporate income tax. And for metropolitan areas and contiguous and adjacent to the NCR, 6% ITH and 10 enhanced deduction and special corporate income tax. All other areas, 7 years, 10% enhanced deduction and special corporate income tax. For tier 3, 6 years income tax holidays, 10 enhanced deduction or special corporate income tax. 7 years for metropolitan areas contiguous and adjacent to NCR. And the same goes for all other areas outside Metro Manila and contiguous areas of NCR. For domestic market enterprises, you can just see here, it's 4 years for NCR and 5 years outside of Metro Manila, but contiguous to or adjacent to NCR, and all other areas 6 years. And for tier 2, it would be 5 years income tax holidays and 5 years enhanced deduction of special corporate income tax. For metropolitan areas, 6 years income tax holidays, 5 years enhanced deduction or special corporate income tax, 7 years for all other areas, 7 years plus 5 years of enhanced deduction and special corporate income tax. For tier 3, it's going to be 6 years income tax holidays plus 5% enhanced deduction and special corporate income tax for NCR. For metropolitan areas or areas contiguous and adjacent to NCR, it's 7 years plus 5 years of enhanced deduction and special corporate income tax. And in all other areas, it's the same, 7 years income tax holidays and 5 years enhanced deduction and special corporate income tax. Let's proceed with the actual process of the BIR of the BOI application. So we have divided into two. Number one, it's the initial consultation and pre-assessment. So first of all, the proposed activity of the applicant should fall within the 2022 strategic investment priorities plan of the government, as discussed earlier. And once we have discussed or sit down with a representative from the Board of Investments, at least we can get higher chances of getting our application approved, then we can already proceed with the registration proper. The registration proper is done by filing the BOI application form along with other supporting documents and the filing fee. We will also the evaluation report, including publication of notice of filing and application and planned visits, shall follow. The application form shall be presented, evaluation report and supporting documents to the BOI Management Committee. And then the client shall await for the confirmation and letter advice from the BOI Governing Board regarding board action. And then submit letter advice to applicant of board action. If approved, the letter of approval shall be given and the applicant shall have to comply with the pre-registration requirements. After that, the successful applicant shall pay the registration fee, and then the certificate of registration from BOI shall then be issued. These are the basic documentary requirements: the cover letter, accomplished, signed, and duly notarized BOI application form 501, Google map of proposed and existing projects, business model, financial projections with breakdown of cost of sales and manufacturing expenses for at least 5 years, the audited financial statements, registration documents such as the certificate of registration, articles of incorporation and bylaws, and other requirements or endorsements as may be required depending on the area of investment or the tier level. The filing date of application shall be the date of the official acceptance. Approved if not it will be considered approved if not acted upon by the BOI within 20 working days. So in a snapshot, this is the registration process. So there's going to be a pre-evaluation, the project evaluation, and if approved, then issuance of the certificate of registration. For the Philippine Economic Zone Authority, let's start with discussing what is PEZA, the services that we offer for PEZA, and the qualifications and incentives, the registration process flow, and other matters for consideration. So PEZA is an attached agency of the DTI. Its mandate is to establish the legal framework and mechanism for integration, coordination, planning, and monitoring of special economic zones, industrial estate parks, export processing zones, and other economic zones. It seeks to transform selected areas in the country into highly developed agro-industrial, industrial, commercial, tourist, banking, investment, and financial centers where highly trained workers and efficient services will be available to commercial enterprises. It also seeks to promote the flow in investors and stimulate the repatriation of Filipino capital by providing attractive climate and incentives. So these are the services offered by InCorp Philippines and Carpo Law Associates. Number one is the project evaluation of application for registration. So we'll make sure that you are qualified and your business activity is among the listed qualified activities for PEZA registration. Next would be the processing of application for cancellation of PEZA registration or temporary closure of PEZA operations, issuance of notice of approval and acknowledge of start of commercial operations, issuance of notice of income tax holiday extension, issuance of VAT zero rating, available incentives and entitlement to special 5% tax on gross income certifications, validation or confirmation of entitlement to income tax holidays, processing of application for letter on accreditation of service enterprises, application for amendment of registration and supplemental agreements, applications for CTC of registration agreements and supplemental agreements, preparation of letter of authority to mortgage, processing of application or special non-immigrant visa, application for amendment of the certificate of registration, importation of specialized vehicles, transport equipment, importation of finished goods, retention of export enterprise registration vis-a-vis excess local sales, processing of letter of approval for the listing of registered activity and registered zone. So these are the eligible enterprises for PEZA registration. Number one would be the Economic Zone Export Manufacturing Enterprise, Information Technology Enterprise. Next, Tourism Economic Zone Locator Enterprise, Medical Tourism Enterprise, Agro-Industrial Economic Zone Enterprise, Economic Zone Logistics and Service Enterprise, Economic Zone Developer or Operator, Facilities Enterprises, and Economic Zone Utilities Enterprises. So yeah, the incentives in general, as mentioned, have been rationalized and streamlined by the CREATE law. So the areas of investment, if they are falling within any of the tiers and located in NCR, in the contiguous areas of NCR or adjacent to NCR and all other areas, so the same table applies. So the investment, the income tax holiday will, as discussed earlier, will be the same. So let's discuss each of the qualified activities. Number one is the Economic Zone Export Manufacturing Enterprise. So an industry is considered as such if it's engaged in manufacturing, processing, or assembly activity, resulting in the exportation of at least 70% of production. So the incentives will be, apart from the tax holidays, tax incentives or fiscal incentives, there will be tax and duty-free importation of equipment and spare parts, exemption from wharfage dues on import shipments of equipment, zero rating of local purchases of goods and services, and exemption from the expanded withholding taxes. The information technology enterprise, on the other hand, refers to IT services where 70% of total revenues are derived from clients abroad. And the activities included in this category would be BPO, call centers, data encoding, software development and application, including programming and adaptation of systems, software for business, media, e-commerce, education, entertainment, etc. So the tax benefits on top of the income tax holiday and or enhanced deduction after the expiration of the income tax holiday would be tax and duty-free importation of equipment and spare parts, exemption from wharfage dues on import shipments of equipment, zero rating of local purchases of local goods and services, and exemption from expanded withholding taxes. For tourism economic zone locator enterprise, it refers to the establishment and operation within PEZA Tourism Special Economic Zone of sports and recreation centers, accommodation, convention and cultural facilities, and their special interest attraction activities, establishment with foreign tourists as primary clientele. The additional incentives would be tax and duty-free importation of the capital equipment, VAT zero rating of local purchases of goods and services, and exemption from expanded withholding taxes. For medical tourism enterprise, this would refer to the medical health services endorsed by the Department of Health with foreign patients as primary clientele. The additional incentives would be tax and duty-free importation of medical equipments, including spare parts and supplies, VAT zero rating of local purchases of goods and services, exemption from withholding taxes. Next would be the agro-industrial economic zone enterprises. For export manufacturing, it would refer to the processing and manufacturing of agricultural products, resulting in the exportation of products. Biofuel manufacturing, on the other hand, would refer to the manufacturing of agricultural crops and eventual commercial processing, resulting in clean energy such as biofuels. The additional incentives are tax and duty-free importation of production equipment, including spare parts and supplies of the equipment and machineries, VAT zero rating of local purchases of goods and services, and exemption from local government fees. For example, the mayor's permit, business permit, etc. For economic zone logistics services enterprise, this refers to the operation of a warehouse facility for the storage, deposit, safekeeping of goods for PEZA registered economic zone export manufacturing enterprises, and or importation of local sourcing of raw materials, semi-finished goods for resale, for packing, covering, including marking and labeling for subsequent sale to PEZA registered export manufacturing enterprise. The non-fiscal or the additional benefits are exemption from duties and taxes on raw materials, semi-furnished goods for resale or for packing, covering, cutting, altering for subsequent sale to PEZA registered export manufacturing enterprise. VAT zero rating on raw materials for checking, packing, visual inspection, storage, and shipping to be sources locally. So the next would be the economic zone developer or operator. This would include the development, operation, and maintenance of any of the above eco zones, including a retirement eco zone park or center in accordance with the accreditation standards of the Philippine Retirement Authority. The additional incentives are VAT zero rating of local purchases, exemption from expanded withholding taxes. Next would be the facilities enterprises, and this would refer to construction or operations of facilities for ecozone enterprises, IT park enterprises, or establishment, operation, and management of retirement facilities. The additional incentives are VAT zero rating of local purchases and exemption from expanded withholding tax. Next would be the economic zone utilities enterprise. And this would refer to the establishment, operation, and maintenance of light and power systems, water supply and distribution of systems inside special economic zones. The additional incentives are VAT zero rating of local purchases, exemption from expanded withholding tax. So the non-fiscal incentives for the PEZA registered activities or PEZA registered business enterprises are simplified import-export procedures through electronic import permit system and automated export documentation system. The non-resident foreign nationals may be employed in supervisory, technical, or advisory position, and special non-immigrant visa for certain non-resident foreign nationals in a PEZA registered economic zone enterprise, including their spouses and married children below 21 years old. Visa facilities assistance to the foreign nationals for the foreign nationals, their spouses, and dependents. So the basic documentary requirements for PEZA registration would be the submission of application through IRS. So this is one of the updates for application with PEZA. So before everything was submitted physically, but now it will be submitted through IRS. It's an online application, an online system. So the submission of application will include the submission of project feasibility study, anti-graft certificate, SEC registration documents such as COR, the certificate of registration, articles of incorporation, bylaws, including the BIR certificate of registration, projected financial statements, the applicant's notarized undertaking, the secretary certificate authorizing registration with the Philippine Economic Zone Authority. So this is the process flow chart. So the proponent will submit to the Director General through IRS the application, and then the evaluation of application shall be done by the ERD or the Enterprise Regulations Department. The presentation of the application shall then be made to the PEZA board. Then you will have to explain to them how we qualify to the listed activities, and then the PEZA board approval shall follow, or the disapproval. And if approved, then the PEZA board shall issue the board resolution of approval, and the legal services group will submission of the proponent of the pre-registration requirements will require the applicant or the proponent of the pre-registration requirements. And upon submission, the preparation of the registration agreement between proponent and PEZA shall follow. And then once done, the signing of the registration agreement and issuance of the PEZA certificate of registration to proponent shall be issued. So these are the fees, or these are the standard pre-registration requirements. The SEC registration of proponent company, acceptance letter or reservation for the economic zone location of the proposed project, copy of the application for environmental compliance certificate filed with the PEZA Environment Safety Group, and the payment of the registration fee. The application fee for PEZA registration is 3,600, and the payment for the Department of Environment and Natural Resources is 4,000, but not all activities are required for this one. And the registration fee is 6,000. I think we're done. If you have any questions, feel free to send us a message and we'll try to answer them later after other speakers will finish their discussions.
Thank you, Attorney Eman. That's actually insightful and very helpful. I think it's noteworthy that you could only register on BOI and PEZA of a new project. You could no longer register to PEZA or BOI if the project or your business activity is already starting.
That's right. So registrants for applicants for registration with the BOI should be a new project, or if an existing company, it should be an expansion project.
Yeah, and if I think we have some few advanced questions before regarding on the extension. There's no extension on the transfer as of yet.
Yeah. So initially, because of the clamor of the BPO sector, specifically the IT BPM sector, the PEZA and the BOI has issued a circular stating that that would allow the transfer of PEZA registered enterprise IT BPM registered enterprises from PEZA to BOI because at PEZA the workforce should be 70% working on site and only a maximum of 30% may work on site, may work from home. So with this issuance of the DEI, the PEZA and the BOI, enterprises with PEZA registered with PEZA were allowed to transfer to the BOI. However, it was only until December 31, and it was the application for transfer, the paper transfer, was extended up until January 31 of 2023. So as of now, there's no extension yet, and we're still hoping that the government will still allow the transfer from PEZA to BOI because everybody's working from home now, right?
Yeah, indeed. So if you have any questions about the presentation of Attorney Emmanuel, you could just type it in the Q&A and we'll try to answer this later after the presentation of the other speakers. So thank you, Attorney Emmanuel, again for that insightful updates about PEZA and BOI. So we will move forward to Carpo Law Associates that will discuss about the BIR LOAs. By the way, before we start, we would like to remind everyone to please update your name, including your company name, so that we could have a better record and we could actually share this presentation after this event. We also have Attorney Mao George Torralba, an associate in Carpo Law Associates. He is a tax and corporate lawyer of Carpo Law. He handles legal matters that generally arise from business conduct, which calls for applying taxation, corporate, labor, and other special laws applicable. His practice areas is tax law, corporate, labor, and contract review. He completed his undergraduate degree at De La Salle College of St. Benilde as Human Resource Management course and finished his law school at Adelaide University School of Law and an IVP member since 2022. So then Attorney Mao and Attorney Attorney Danny will have this. We will be discussing the BIR LOA and how you could strategically address if you receive one. Okay, so I'll giving the floor to Attorney Mao to start the presentation.
Hi, Sherman. Thank you so much for the introduction. Hi, I'm Attorney Mao, and I will be joined also by Attorney Danny. So to begin, I'll just share my screen. Thank you so much. Okay, hi, I'm Attorney Mao of Carpo Law Associates, and yeah, pardon that I don't have a background with me because if I put it on, I will blend in, so it's not very sightful. Anyway, so we'll be discussing about the BAR audit process. So and our outline of our discussion would be just basically the assessment process, the administrative aspect of it, and the judicial, and as well as some relevant regulations which have been updated since beginning 2021. So to begin a discussion on the BAR assessment, it must be noted that the BAR assessment is it's commenced by the issuance of a letter of authority. So for the benefit of those who haven't seen it yet, a letter of authority is basically the source of authority of the revenue officer to examine, verify, and scrutinize a taxpayer's books of accounts in relation to his internal revenue tax liabilities for a particular period. So it must be emphasized here that it must be for a particular period, which I will be highlighting later on. So, okay, so this is what a letter of authority looks like. So as you can see here, there's a designation of an RO, a revenue officer, which we blanked out. And you can see here also it pertains to a particular period, which in this case is January 1, 2015 to December 31, 2015. And it is signed by the regional director. And also worthy of note as well that like the internal revenue taxes are also identified herein. Okay, so a letter of authority is not just a letter, but it is also a substantive requirement with regards to due process, because as held by the Supreme Court in the landmark case of Medicard Philippines versus CAR, at any tax assessment without an LOA is a violation of the taxpayer's right to due process, and it is void. So any sort of demand for the payment of taxes therein is becomes void. So okay, so as noted by usually through correspondence with the revenue officer or by the regional director in certain cases, these are the common reasons why a taxpayer has received a letter of authority. And I highlighted tax compliance deficiencies because as I think the bulk of our issue with LOA, I mean our clients who have received LOA stemmed from it's usually the late submission of AFS, of an audited financial statements, or an amendment of the audited financial statements. That is one, or they failed to file the corresponding returns, usually withholding taxes or the VAT returns. Now there's notable changes in revenue and or cost of sales and services. And this third point on closure of business, this has been a recent development. While the BIR has been empowered by law to conduct a mandatory tax assessment with regards to businesses undergoing dissolution, it has not been enforced up until about third quarter of 2022. So once received the letter of authority, like on our end, if let's say we're engaged, we will be looking at among others these 5 points. So the taxable period, the assigned revenue officer, date of issuance, prescriptive period, and mode of service. The reason for which is that these 5, in case there's an impropriety or a cause for contesting with regards to these, we can serve to sort of invalidate the LOA. And basically the grounds here, especially with regards to the taxable period, assigned revenue officer, date of issuance, mode of service would be due process. So please bear that in mind as well, that due process will be like a recurring theme with regards to letters of authority. So anyway, so for the taxable period, as noted in the definition I cited earlier, it should cover a taxable period not exceeding 1 taxable year. And in the case of CAR versus Sony, it was noted that the LOA that was sent to them covered an audit of unverified prior years. So, and the Supreme Court struck it down as it is prohibited. And it'll be tantamount to a fishing expedition basically by the BIR. And in every assessment, the taxpayer should at least expect some sort of resolution. And if the unverified prior years should be allowed to stand, then the taxpayer will be at the mercy of the BIR for long. Anyway, so and the next point is assigned revenue officer. Okay, this is a recent prior to this ruling by the CAR, by the McDonald's case, there has been instances when the BIR, like instead of a LOA, in case a revenue officer has been reassigned or transferred, they have been issuing various papers, some of which is a memorandum of authority, others is a referral memorandum, and the Supreme Court in this McDonald's case clearly and categorically stated that it should be a letter of authority, bearing in mind the use of the word shall. It means it should be an LOA, nothing more, nothing less. And this has been the controlling doctrine with regards to assigned the transfer or reassignment of a revenue officer since May 10, 2021. And in a more recent case of Commissioner of Internal Revenue versus Red Ribbon Bake Shop, it adopted the case, the CTA adopted the doctrine in the McDonald's case, because as I explained earlier, in this case, it was instead of an LOA, it was a memorandum of authority that was used by what was used in lieu of a LOA. So in adopting the ruling of the Supreme Court in McDonald's case, they adopted it that it should be an LOA only. So on the regards of date of issuance and date of receipt, yes, as provided by regulations and by jurisprudence as well, it must be served or presented, must be presented or served with the taxpayer within 30 days from the date of issue. Otherwise, it will be null and void. But it is easily cured by revalidation. So unless revalidated, it will be null and void. So, and upon receipt of LOA, the revenue officer has 120 days. Conduct his audit and submit the required report of investigation. Okay. Another is the prescriptive period. So one thing to note is that if let's say this is 2023, right? Let's say 2023, you received an LOA for 2014, to my understanding. Well, if the last day of the filing of return is beyond 3 years, if there's no allegation of fraud, then it should be prescribed and it's void. And also the modes of service. There are 3 modes of service recognized by which is allowed by the BIR. Still worthy of note is that I must highlight as well at this point that service by email is not yet allowed by the BIR. It's not the service contemplated by the law and regulations. So the 3 modes of service are personal service, substituted service, and service by mail. So personal service is straightforward. So let's just skip to substituted service, which has been quite a source of a lot of cases. So substituted service means, say, like if personal service cannot be effected, it'll be the notice will be, or the assessment notice will be left at the registered address or with the person having charge thereof, or in the second point, with his clerk or with the person having charge thereof. This highlighted phrase has been a source of many CIR cases, because there were instances where the assessment notices or the LOA was left to usually the receptionist, some cases security guard, and the CTA has ruled that unless they have been clothed with some vestige of authority, let's say by a special power of attorney or a board resolution, it is not the proper service. So as I will explain here in this case, a clerk or a person having charge thereof means it's a competent person managing the office or place of business and must have sufficient notice to understand the obligation of the defendant in the notice, its importance, and the prejudicial effects arising from inaction. So as can be seen by the definition, it's not just a person who's sitting in the front desk. It must be a competent person managing the office or place of business. So the type of person contemplated here would be someone with a higher position. So usually it's a manager, like a compliance officer, I think, to my understanding, can be considered as a competent person, depending on whether it's his task to receive notices. So in this case, the CTA held that the security guard is not a clerk or person having charge thereof of the business. Well, he may be in charge of security, but he's not in charge of running the business. And in this case, the case of Gateway Rural Bank, the loan clerk who receives mail matters is not considered as the clerk, because it has to be a person managing the office or place of business. And then service by mail is very straightforward. It's a registered mail or a reputable professional courier service. To my understanding, I think LBC and then I think Ninja Van has been accredited as a professional courier service, especially by the Supreme Court. So I think a notice may be sent through that avenue. And in case the unavailability of registered mail or reputable courier service, that is when ordinary mail may be resorted to. So then again, a proper service violates the taxpayer's right to due process. So as I explained earlier, a violation of due process, any tax assessment issued in violation of the due process rights of a taxpayer are not void. So it can never be final, executory, and demandable, and it can't be the basis for the collection of income tax from petitioner. Because in the first place, it would mean the assessment was not valid to begin with. So a way to contest the improper service is one is he never received it. So if in case the taxpayer denies it, the burden of proof shifts to the BIR to prove by competent evidence that such notice was indeed received by the addressee. So in cases where it was mailed, the registry receipt or the registry return card will be a proof of receipt by the taxpayer. And also worthy of note in this case of CIR versus Unisphere, this is why I always ask I always inquire whether the client has informed the BIR of the change of address, because if it has informed the BIR of the change in address, and the BIR sends a notice to the old address, then the BIR is kind of stopped to the BIR may be in estopel with regards to the reglementary periods of regards to assessments. So this is very critical. So as much as possible, the moment of the address changes, the BIR must be informed. Okay. So yes, to reiterate, the void LOA means the assessment is void. So let's just move on. Okay, so after the LOA has been received, and then I need to note also that there will be a notice for presentation of documents. So once the notice of presentation of documents, let's say you comply with the notice, the revenue officer will schedule a schedule a discussion, and then after that discussion, it is where she will note discrepancies, which is here in a notice of discrepancy. So before, this used to be called a notice of informal conference, but but now it's denominated as a notice of discrepancy. So a notice of discrepancy is received by taxpayer if he's found liable for deficiency tax or taxes in the course of investigation, and it is accompanied by a report of investigation informing the taxpayer in writing of the discrepancies. So an example of a notice of discrepancy or an NOD would be this one. So excuse me. So as you can see here, there is a mention of the I hope you can see it, but it has its basis in the in the letter of authority. It has a designated revenue officer, a group supervisor, and then the details of discrepancies are highlighted in the next document, and which is right here. So basically, this is not the final assessment yet. This is just, as a matter of practice, it is usually just the table assessment by the by the revenue officer. So this is an opportunity for the taxpayer to present his reconciliation. It's usually by way of a working paper with the proper substantiation attached as a supporting document. So it is worthy of note here that the moment the notice of discrepancy has been served, interest starts to run. And it is at this point where the taxpayer must be able to settle this as early as possible, because to delay the procedure from this point on, even up to the fan, would mean that interest will accrue. And if you can see here, the 15 million will definitely balloon. So this is what we try to avoid. So with regards to LOAs, as a matter of practice by our firm, we try to deal with it as early as possible, sort of like nipping it in the bud, so to say. Okay, so so after receipt of the NOD, the discussion will be scheduled. This is an opportunity for the taxpayer to present the substantiation documents, and this is at this point in time. This is where, I mean, on my end personally, we try to get on the good side of the revenue officer. I mean, we're not, like, legally speaking, but 'cause sometimes some periods can be relaxed to our benefit. But anyway, okay. So after the receipt of the NOD, and the conclusion of the discussion, a preliminary assessment notice will be issued within 10 days. So this is pretty much the assessment notices. Okay, so let's start with the PAN. So this is issued to the taxpayer, informing him of the findings of the revenue officer if, after review and evaluation of the records, there is sufficient basis to assess the taxpayer for any deficiency taxes. So this is the requisites of a valid PAN. Yes, so as you can see here, the first requisite pertains to service. And as I explained earlier, this ties into due process. Second one, conducted with the scope of authority. This one also ties into the definition of a LOA. So if the LOA is for a certain year, and then the PAN, excuse me, or certain year or a certain tax item, and the PAN exceeds that, then it is void. Must be in writing and contain the facts in the law on which the proposed assessment is based. So I recall reading a CTA case where the PAN only had numbers, but it didn't have legal justification. It didn't have facts, just the numbers. I recall, yeah, and the CTA, rightly so, deemed the PAN as void. So, and here also, this is kind of also, it must be issued by the CAR or its duly authorized representative. So in practice, yes, it's issued by the CAR or its duly authorized representative. But as you can see in the next slide here, the CAR is, the commissioner is also right here, and also the regional director. This is what to expect with regards to the signatory of the PAN. And as you can see with our sample PAN here, yes, I'm assuming this is based on the letter of authority, but the proper items of tax are delineated, and then there is legal basis for the assessment cited here. As you can see, the surcharge is a statutory basis on Section 48, and interest was imposed pursuant to Section 49. So as far as compliance is concerned, this is fully compliant. So what to do after receipt of a PAN? Then the taxpayer is confronted with three options. It's either to pay the assessment, file a reply, or he may ignore. So payment of assessment, well, yep, It's pretty straightforward. Once paid, the assessment is closed, but it's a matter of formality in the procedure. An FLD fan shall be issued because in a PAN, so an FLD fan shall be issued to formalize the assessment because and then the payment form will be duly prepared, filed, and paid. And then reply to PAN. Here in the reply to PAN, this is some sort of, the form of a reply will usually be in the form of a like a position paper of sorts. So it's not just, you're not just as a tax practitioner, we're not just gonna say this is the wrong assessment, but more of this is the wrong assessment because based on the law, you should not have done this, and then we have substantiation. So basically, it must be defended, must be contested based on the facts, based on the record, based on law, and based on regulations. So, and upon receipt of the PAN, the taxpayer has 15 days. Or he may choose to ignore the PAN, which means the taxpayer shall be considered in default, and an FLD fan will be issued. An FLD fan means a formal letter of demand or a formal assessment notice, by the way. So, an FLD fan. So what is an fan FLD? It's a formal letter of demand for the payment of deficiency taxes of a taxpayer in the following instances. So failure to file his or reply to a PAN within 15 days from receipt of PAN, or the reply to the PAN preliminary assessment notice is without merit. So this is why I explained earlier that the reply should be really substantive, because if the BIR finds it substantive and meritorious, the assessment is cancelled. So, okay. So, requisites of a valid fan, basically the same as the PAN, but with the added requirement that it must contain a definite due date for payment. Because in this case of the CAR versus fitness by design, there was no definite due date for payment. Supreme Court held that it must contain it because otherwise it's not the fan contemplated by law and by regulations. So I am hoping you can see it here, but based on this final assessment notice, the date of March 31, 2022 was provided as a deadline for the payment of the tax liabilities. So kind of similar to the PAN, the taxpayer is confronted by 3 courses of actions, either to pay, to file a protest, or fail to file a protest. Of course, the third option is not ideal because it will mean the assessment becomes final, becomes due and demandable, and failure to pay will mean that the CAR has cause to file a civil case for collection in court. And also, given that this is already on the part of the assessment stage, it's already the fan. It means interest has accrued since the receipt of the NOD, the receipt of the PAN. So this is not the course of action we would like, definitely. So as also noted here that unlike in the PAN, the preliminary assessment notice, the form of contesting in writing is now called a protest. If in the PAN it's a reply, FAN is a protest. And it must be noted as well that an offer of compromise may be made after the filing of the protest. So yes, payment is straightforward. And then it gets the FAN FLD. So the taxpayer is given 30 days from date of receipt. Must be in writing, addressed to the CAR. Must be filed by the taxpayer or its duly authorized representative. And it must indicate if it is a request for reinvestigation or reconsideration. These two highlighted words are very critical because these are different in nature and they partake of the different regulatory periods. So consideration means the examiner, the revenue officer will reevaluate based on existing records. So, and on the other hand, reinvestigation means that you're seeking that the revenue officer evaluate records based on the existing ones and also on newly discovered or additional evidence. So the protest should contain the new evidence and the annexes intended to be presented. And as a matter of practice, reinvestigation is much more favored than reconsideration because of this third point right here. Documents must be submitted within 60 days from filing a protest. The implication of that is the taxpayer is afforded 2 months, about 2 months to contest the findings of the BIR. So yeah, this is the more favored remedy. I am not aware of anyone who utilized the reconsideration. So these are the common defenses to be raised in the reply, as I explained earlier, especially with regard to the notice of discrepancy and in the PAN. So it relates to the substantiation, because some revenue officers will be insistent that it should be official receipts, should be or sales invoices. It should, and as provided by law, it's not supposed to be limited to that. There are other ways to substantiate expenses. So another one is when the final assessment notice includes new assessments. So, and then another one is improper service. So yes, in order for assessments to stand the test of judicial scrutiny, the assessment must be based on facts. So this highlighted point has been this has been sort of one of our tools in contesting PANs, because this is where we notice sometimes that the BIR makes an assessment based on estimations. Estimations are not facts, so definitely. So this is one of our angles of attack with regards to contesting the assessment notice. So another one is a prescriptive period, and one thing to note: after filing the protest, the CAR or its authorized representative may deny, may fail to act, or may cancel the assessment. So the third point is always the ideal result. But in case of denial, it must be determined first if it was the commissioner who denied it or the duly authorized representative. Just to give everyone a background here, if it is the duly authorized representative who denied it, an appeal may be made to the commissioner. But if the commissioner is the one who denied it, the usual next step would be, in case there is no resolution, there is no settlement, it would be to go to the Court of Tax Appeals. So I will explain it a bit in detail. So denial by the CAR means appeal to the CTA within 30 days from receipt, or he may pay, or he may request for reconsideration of the said denial. But as noted by the Supreme Court and also by way of practice, this is not ideal, because the moment of time it takes for you to reconsider could have been the time that you may have used to file an appeal to the CTA. Because once a motion for reconsideration has been filed, a 30-day period to, to appeal to the CTA, not be told, and the taxpayer will be left, once a 30-day period has been lapsed, the taxpayer is basically he has no more options. So in case of the denial by the by the commissioner's representative, appeal to the CTA, administrative appeal to the CIR, or payment of deficiency tax due. So it must be noted here that there is no request for investigation once the CIR's authorized representative denies the protest. So this is just a request for consideration. So the commissioner will be basing the reconsideration on existing documents. So in case of inaction, this is where, well, as law students would study in taxation law, where this is where the 180 plus 30-day period comes in. So inaction by the CIR from the moment of submission, depending on whether it is a request for reinvestigation or consideration, there will be a 180-day period. And then once the 180-day period has been lapsed, an appeal to the CTA must be made within 30 days. But if the taxpayer does not appeal to the CTA within the 180 plus 30-day period, they may choose to wait for the decision of the commissioner or the authorized representative, and then once received, an appeal to the CTA may thus be made. So this is the flow chart of the whole assessment process, as I explained earlier. So receipt of LOA, this is where the subpoena may be made, investigation, discrepancy, issuance of PAN. Yep. I believe you will be sending also these to you upon request. So yes, and then this one, as I explained earlier, this is basically the flow chart form of what I have discussed earlier. So yeah, as noted here, no investigation allowed in administrative appeal to the CIR. And yes, in case of CIR denial, motion for reconsideration is not advisable. 30-day period to appeal to the CTA is not told. So it continues to run, not to the taxpayer's benefit. So I believe I have covered the administrative portion of the assessment procedure. So I will now turn over the floor to Attorney Danny. Thank you very much.
Thank you, Attorney Mao. So, Attorney Danny.
Thank you.
Attorney Danny will continue the presentation of the BIR LOA. Our next speaker will be Attorney Danny Eseque. She is a senior associate of Carpo Law Associates, and she expertly handles multiple clients' needs, including corporate governance, business transactions, regulatory compliance, tax planning, tax compliance, and tax dispute resolution. Her practice areas is on tax law, contract review, special projects, and real estate. She completed her undergraduate degree at the La Salle University, Manila, political science course, and finished her law school at De La Salle University College of Law, and an IBP member since 2017.
Okay, can everyone hear me?
Yeah.
Okay. Good morning, everyone. So I'll continue on with the proceedings for the LOA. So Attorney Mao has already given you the overview of how to go about with the administrative remedies. And in the event that no compromise agreement has been settled with the BIR during that stage, the next remedy available to the taxpayer would be to proceed with the judicial process before the CTA. So I'll give you first a brief background. So with the CTA, as mentioned, the appeal has to be made within the 180 180 plus 30-day period. Otherwise, it will be denied for being filed out of time. So even though you do have the required substantiation documents, or you do have merit in your case, if the appeal was filed out of time, then it will be denied outright by the CTA division. And here are some of the usual remedies with the CTA. So when filing the petition with the CTA, it's called a petition for review. You can also file, along with it, a motion for suspension of collection of taxes. So earlier it was mentioned that if the petition was filed out of time, or if you did not pay the necessary amount within the period that was required, then you have no more recourse. So what do you do if you want to file a case with the CTA, but you also don't want to pay the taxes? So what you do is you file the petition for review, and then you file along with it the motion for suspension of collection of taxes. Why? Because this motion, if granted by the CTA, it will toll and will suspend the period for the BIR to collect the taxes from the taxpayer based on the FAN that was issued. And another remedy is to still enter into a compromise agreement with the BIR. So just to give you an overview, during the administrative process and also during this initial stage in the judicial proceedings with the CTA, the taxpayer and the BIR are still given the freedom, if you will, to enter into a compromise payment of the taxes that were assessed. So more often than not, for some clients, they do opt to still pay. Sometimes it's 40% of the basic assessment. And there are some clients who do opt to push through with the proceedings with the CTA. And in most of those cases, the CTA favors the taxpayer because they do have they were able to provide the necessary documents. So here's the general process flow for the proceedings with the CTA. So you will notice here in the center, these refer to the 3 stages or 3 levels of the appellate process. So the first would be with the CTA division. And then if there's still an unsatisfactory or unfavorable ruling there, you can appeal to the CTA and bank. So that's the EB. The CTA and bank is basically comprised of all the justices of the Court of Tax Appeals. The division is comprised of 3 justices. So if it's going to be the NBank, it's at least 9 justices who will be ruling on the case. And then if there's still an unfavorable decision by the CTA and bank, then you can move ahead and appeal to the Supreme Court. Please take note that for each of these stages, between the CTA and the Supreme Court, there are concomitant or corresponding filing fees with the courts. So you may also need to take that into consideration when deciding if you're going to proceed with the judicial case before the CTA. Okay, so just a few general tips in handling assessments. We'll also discuss after this some of the general defenses that you can raise during the negotiations with the BIR based on some of the common items that appear in the preliminary assessment notices or the final assessment notices that we've encountered. So before that, hopefully to avoid any assessments, please make sure that the figures in your tax returns, your alpha lists, and your financial statements are all consistent before filing them. And along with that, also please check that the figures or the entries in your receipts and your invoices are all correct. I've encountered a few clients who've been audited by the BIR, mainly because the figures that they submitted in their official receipts did not line up. So what they did was the gross amount that was indicated was not actually the gross amount, it was the net. And they still enumerated the VAT and the withholding taxes in the side table in the receipts. But then the figures there, of course, they did not line up with the figures that were declared in their financial statements and in their returns. So they were audited for a lot of tax deficiencies. So that's something that you will want to avoid. And then in the event of an audit, double check the values for each assessment items, because in some cases or some instances, the examiner may have made a wrong computation. Also, please make sure that the documents or the books of accounts, if you are going to submit them to the BIR, are the correct books of accounts. I am aware that there are some companies that maintain at least 2 sets of records. One was meant for internal records and another one is meant for submission. There have been some instances where they have been interchanged, so please watch out for that. Or if you are going to maintain that practice, please make sure that all the records are clean. And also, it's best to resolve the issues that arise from the audit during the investigation level, as already mentioned by Attorney Mao. We prefer this to be settled during the investigation because of the possibility of interests and penalties accruing after the FAN has been issued. And also, do not volunteer to submit any documents to the BIR that were not included in the list that they provided. So if you do receive a letter of authority and then subsequently a notice of discrepancy, there will be a checklist of requirements attached to both of those letters. Please limit the documents, any documents that you will provide, to whatever are in those checklists. And lastly, do not antagonize the BIR. Well, for obvious reasons, because we want to settle this issue or any issues that may arise in the LOA as early as possible to avoid any interests or any ballooned audits. Okay, so let's move ahead to some of the general defenses for the common items. So I have here some of the common assessment items that have been appearing. So it's based on income tax, VAT expanded, and withholding on compensation. There's also fringe benefits, the documentary stamp tax on loans, preferential treaty rate applications, income tax holiday applications based on the IPA discussed earlier by Attorney Emmanuel, and the improperly accumulated earnings taxes, and some intercompany transactions. So let's move ahead with some of the items for income tax. Okay, so first would be the disallowed expenses. More often than not, it's going to be disallowed expenses for failure to withhold. I'll discuss this in further detail later on when we discuss the items for expanded withholding and withholding on compensation, because once you've already been able to substantiate the items under those two assessments, this item under the income tax assessment will also be removed. Okay, and then for undeclared income from unaccounted sources. So this often appears in BIR audits, mainly because there's this presumption by the BIR that if there's a discrepancy between the figures in the tax returns, the income tax return specifically, and the financial statements and the VAT returns, they would immediately presume that there was undeclared income, and then they would just merely cite that there were unaccounted sources. Take it as it is from the name. But the CTA has ruled that a presumption of income cannot be made from another mere presumption that there was an underdeclaration. So assessments have been canceled or have been deemed void by the CTA if it was merely based on this, because there needs to be a proof that there was actual income, or there was income that was actually gained by the petitioner. And then there's underdeclared expenses. So there have been instances that clients have not declared all of the expenses that they have for a fiscal year, and the BIR has audited them for that. But then again, the taxpayer is free to declare the expenses that they want. Can be less or can be the exact amount of expenses that they have incurred, so long as they do not claim any amount beyond the amount that they have actually incurred. If you underdeclare your expenses, that's okay. It should not be an item under your income tax assessment. And you can cite this case with involving the Philippine Daily Inquirer. Okay, so we move on to the VAT assessment. So again, we see here the undeclared income. So you will notice more often than not that VAT assessment items are hand in hand with income tax assessments. So if you are able to do away with the undeclared income item under your income tax, then there's going to be no VAT assessment on that item as well. So again, if there's going to be only the presumption that there was an undeclared income, then the CTA has ruled that any adjustments or disallowances that were not shown to be a flow of wealth or actually income received, then there should be no assessment. And then there's the issue of the timing difference. So this is based mostly on the gross sales that are declared in the income tax return and the return revenue in the value added tax. So the CTA has ruled here that they are aware that this discrepancy can happen, and they do acknowledge that it's a timing difference issue that should not be the basis for an assessment item because of two different accounting methods. So there's the cash method and then there's the accrual method. If the accrual method has been used by the taxpayer, then they do acknowledge that there could have been a timing difference. And then if that happens, it's the BIR's burden to prove that there should have been an assessment in this case. Okay, next would be the interest income and the interest expense. So you just need to take note here that if you do have any interest expense claimed as a deduction, you have to reduce it by 33% of the interest income that's declared. So this is still the rule even after the amendments. Okay, so we move to the withholding on compensation. So what the BIR often does is they would compare the figures in your AFA lists, your summary lists, your financial statements, your income tax returns, and then they would come up with a discrepancy if there's no consistent figures there. That's why I told you earlier that before you file anything, before you submit anything to them, make sure that all the figures are consistent. So with the withholding on compensation, the following items are exempt from income taxes. So it's salaries of minimum wage earners, 13th month pay and other benefits. So it's capped at 90,000 pesos. The mandatory government contributions. So this is the one that are paid to the SSS, PhilHealth, the HDMF. And then any compensation that's not exceeding 250,000 based on the amendment under train law, these are all exempt from income taxes. And then a reiteration that holiday pay, overtime pay, night shift differential pay, and hazard pay that are earned by minimum wage earners or statutory minimum wage earners are still exempt from withholding taxes on compensation. But please take note, though, that withholding taxes of employees of area or regional headquarters of multinational companies, regional operating headquarters, offshore banking units, subcontractors, and petroleum contractors, these are subject to withholding taxes. Okay, and then for expanded withholding taxes, if you're not yet aware, expanded withholding taxes are due on companies that are considered as top withholding agents, or if you're part of the TAMP program of the BIR. How will you know if you're among these entities? You should receive a notice from the BIR notifying you that you're already considered a top withholding agent or you're part of the TAMP for this specific fiscal year. And once you receive that, then these rates would apply. So there's 1% on supplier of goods, regular supplier of goods, 2% on regular supplier of services, 5% rentals, 10 or 15% on professional fees. So for the professional fees, the delineation between the 10 or 15% is very specific. For this item, more often than not, the BIR is going to assume that it should have been 15% and not 10%. That's the applicable rate. But what you can do is prove to them that the proper rate should have been really 10% on the professional fees based on the gross income for the taxable year, if it's 720,000 only. So this is for GPPs. Okay, if you recall, so we have here the term regular supplier of goods and regular supplier of services. So the term actually refers to suppliers with whom the taxpayer has had at least 6 transactions, regardless of the amount per transaction in each year. But it does not include any casual purchases of goods or services. An exemption, though, if the casual purchase or the single casual purchase involves at least 10,000 pesos. In that case, it would still be considered as a regular purchase or a regular supplier of goods, and it's going to be subject to expanded withholding tax. Okay, so the same rules will apply to resident supplier of services other than those covered by separate rates of withholding taxes. And just maybe to take note, purchase of goods and services using credit cards are not subject to expanded withholding tax. Okay, and then for fringe benefits. So fringe benefits given to managerial employees are generally subject to final taxes based on the grossed up monetary value, except if the fringe benefit is given, if you'd see here, it's for the benefit mainly of the business of the employer or for the convenience or advantage of the employer. In contesting this assessment item, you will also want to take note of the computation by the BIR for the grossed up monetary values, because there are specific computations depending on what the benefit given was to the employee. So take note of that. And then we have documentary stamp taxes on loans payable. Instructional letters, journals, and cash vouchers evidencing any cash advances to affiliates are considered as loan agreements, or they will qualify as loan agreements, and they're subject to DST. But any capital infusion on a branch office is not subject to DST provided, that it's booked as a home office account. Okay, and then we have the preferential treaty rates. So this is based on, or it refers to the rates that are included in the tax treaties entered into by the Philippines with other nations or other jurisdictions. We have 2 landmark cases here, and later on we'll discuss in our regulation updates a few relevant regulations issued by the BIR recently in terms of applying for the treaty rate. So in the first case given by the CTA upheld that it's required for the taxpayer to file the application for TTRA before they can avail of the treaty benefits. Later on in 2009 and in subsequent years, the CTA reversed itself. It considered the decision in the case in 2005 in the Myron case as not binding. It's a non-binding precedent. Why? Because tax treaties are entered into specifically to eliminate or minimize any impact of possible double taxation. And it should not be hampered. Any claim based on it should not be hampered by any administrative issuances or administrative requirements by the government. But later on, I'll mention to you right now that we do suggest, still for prudence, that if you are going to avail of a treaty benefit, it's best, or it's more prudent, that you avail of a tax treaty relief application, because even though there are these decisions by the CTA, the BIR is still notorious in looking for any documents or substantiation requirements stating that the company is eligible to claim such benefit. based on the previous citation under our tax laws. Okay, and then we have the income tax holiday. So it was mentioned earlier during the discussion of Attorney Emmanuel that there are income tax holidays available under the BOI and also in the PEZA. So what you can do here is you can cite the number of years that the company is eligible to avail of the income tax holidays, and also if you're registered under PEZA, that there's the special rate after the expiration of the first years or the extension. There's the 5% special rate that's applicable. So what you need to do here is you need to present the certificate of registration and to prove that the income derived is based on the registered activity in that registration. So also please take note of how many years the income tax holiday has been granted to the entity, because there can be instances where the income tax holiday was extended. So just make sure to check on that. Okay, and then the IAET, or the improperly accumulated earnings tax. So this item has already been repealed under CREATE law recently, but please take note that the repeal or the non-application, it only applies to the taxable year or for all the fiscal years ending after the effectivity of CREATE, which was in April 2021. Okay, and then we move ahead to some intercompany transactions. So for loans and advances, just take note that journal vouchers, debit memos, bank advances are loan documents, and they're loan documents for DST purposes. And again, capital infusion on a branch office is not subject to DST, provided it's booked as a home office account. And then interest expense, there's an interest expense payable to the affiliate company that's an non-resident foreign corporation, and it's generally 20% final tax, unless either of the companies file for the tax treaty relief with the BIR. So this is one of the reasons why we do still suggest that the company file for TTRA, so that it would be easier to claim the tax exemption. Okay, and then for allocated costs and reimbursable expenses, so reimbursements of costs do not constitute as income of the parent company. Therefore, it's not required, it's not subject to any withholding taxes. And then please ensure that these expenses are supported by a cost allocation agreement, because again, the BIR is very strict when it comes to the substantiation documents. And this is based mainly on the principle that any claim for exemption, any tax exemption, is not favorable to the state, because the taxation is the lifeblood of the state. So there's the presumption that every citizen, every resident is required to pay the necessary taxes. And if you're audited by the BIR, it's part of the necessary taxes, and there's a presumption of regularity on their end. So please, as much as you can, substantiate any claim for exemption or expenses or deductions that you're going to make. Okay, and then please take note, if one of the affiliates in a group of companies is established mainly to perform services for the whole group or to perform services for one of the other affiliates, the cost billed to each of the entities will be subject to income tax and VAT of that one affiliate. And the counterpart expense of the related parties may be subject to withholding taxes, depending again on the type of service. Okay, so now let's move ahead to some of the latest regulations from the BIR. So first would be a couple of regulations in 2021. This involves the imposition of VAT, 12% VAT, and it's 0 rating. So if you recall, after the effectivity of CREATE, there were some issues arising on 0 rating of VAT. So after that happened, the BIR issued Revenue Regulation 5-2021 and 15-2021. So it noted that transactions that transpired between June 27 to June 30 will be subject to 12% VAT. But later on, based on 15-2021, the imposition has been deferred and has not been lifted to date. Then what happened after that? After that, there have been a lot of discussions between the BIR and the PEZA entities through PEZA. So the BIR released 21-2021. It clarified that VAT zero rating on local purchases is still applicable, but it's limited only to goods and services that are directly and exclusively used in the registered project or registered activities. And that the zero rating on the purchases will be granted upon endorsement of the IPA or the Investment Promotion Agency. So that's either the BOI or the PEZA, in addition to other documents that may be required by the BIR, among which is the sworn affidavit under RMC 84-2022. And then again, after that, there were still some discussions between the investment promotion agencies and the BIR because apparently the issue has not yet been completely resolved. So what the BIR did, they issued RMC 24-2022, further clarifying the issues surrounding the VAT zero rating of transactions involved with the PEZA registered entities. So it compiled the issues that were raised under 9-2021, 15-2021, and 21-2021. If you want, you can actually view, or you can go over the entire circular, the memorandum circular. It's quite lengthy and it's in a question and answer format. But the gist of it is that the BIR mentioned effectively zero-rated sales will only apply to sales of goods and services rendered to persons or entities who have direct and indirect tax exemption granted pursuant to special laws or international agreements to which the Philippines is the signatory. So it's basically stating that it's upholding the Revenue Regulation 21-2021 and also recognizing the tax treaties to which the Philippines is a signatory to. And then we have 17-2021. If you are not yet aware, there was an estate tax amnesty implemented, I think this was in 2019, and it was valid for a couple of years. So it was only until 2021 supposedly, but then because of the effects of the pandemic, the BIR issued the regulation extending the deadline for availing this form of tax amnesty. So take note, it's only up till June 14 of this year. And it's applicable only to deaths up to December 2017. Okay, and then for this specific regulation, I will turn you over to Attorney Mao.
Okay, so for RMO, Okay, so for RMO 14-2021 and RMC 77-2021, as explained, but as brought up by Attorney Danny earlier, with regard to the preferential treaty, finally the BIR has streamlined the availment of tax treaty benefits. So before, to my I recall, with regards to getting a tax residency, they call it the court, a certificate of residency for tax treaty purposes, and they no longer issue that. So instead of which, it is a tax residency certificate. And apart from a tax treaty relief application, there's also the introduction of a request for confirmation. So basically, as I have enumerated here, if in the payment of income, treaty rates were applied, it's the request for confirmation that should be applied with the BIR. But if regular rates are applied and instead of the treaty rates as appropriate, depending on the treaty, it is a tax treaty relief application that should be applied for. And in the TTRA, it could be made simultaneous as well with the claim for refund. And one RFC in TT or TTRA may be filed for long-term contracts effective for more than a year, subject to annual updating. So, in case of let's say, um, a compensation payment made to a non-resident not engaged in trade or business who is subject to a treaty rate, um, that the withholding taxpayer, the withholding agent may apply the treaty rates and um, use the request for confirmation. And then if it is lasting for more than a year, he may just update it with the BAR. And then instead of the usual BAR ruling, which was the end result of a relief application before, it is now denominated as a certificate of entitlement. Next slide, please. Thank. Okay, so for the next slide, with regards to the receipts, it's just well, if you may recall, like before, receipts had a 5-year limit, and then now they removed such limit by virtue of a RR 6 2022. But nonetheless, the unused receipts bearing the old mandated phrase may still be used until exhaustion. And as regards to the next regulations on revenue regulations 13-2022, must be noted before as early as 2012 and 2014, as cited herein, equity-based compensation used to depend on the kind of employee. So if it was a supervisory or managerial employee who exercised the stock option offered by the employer, it was subject generally to a fringe benefits tax. And if it was a rank and file employee, it is considered as part of his compensation income, which is subject to the normal income tax rates. But by virtue of revenue regulations 13-2022, to my understanding, this was issued October of last year. They didn't. It removed any such distinction as to the type of the employment status of the person who exercised it. So regardless of whether it is a supervisor, managerial employee, or a rank and file employee, it is considered compensation income under Section 32, which is gross income. So it is part of gross income. It is subject now to the normal income tax rates. And yes, and I think this concludes our part of the discussion. Thank you very much, Attorney Danny.
Thank you, everyone.
Thank you,
I
Attorney.
will give you back to Sherwin.
Yeah, thank you, Attorney Mo and Attorney Danny. This is actually very informative and overwhelming for a non-accounting and tax person like me. So before we move forward from the last part of our event, let me just share my screen again. We will actually have our next webinar that tackles about Data Privacy Act, managing your risk and compliance for corporations. So we actually invited Attorney EJ Katakutan, a senior associate lawyer from Carpo Law Associates. So we will send the invite if you're interested for this webinar. This is also a free webinar. Just let us know so we could have you on the invite. And now we will move to the question and answer. We actually have few questions received here, and speakers, could you open your mic and your video so we could try answering those questions? Okay. We have here from an anonymous attendee. First question is for Attorney Eman. The incentives identified per here will be on top of the ITH or income tax holiday for companies located in PEZA zones.
Am I audible now? Hello? Yeah, so to clarify, does the question sender mean incentives for eligible activity? Because if the answer is yes, the additional incentives discussed earlier will be on top of the income tax holiday. Otherwise, the income tax holiday based on the table shown earlier will be the same. So with the passage of the CREATE law, the grant of income tax holiday has been rationalized and made uniform between BOI and PEZA. Thus, to know how long the ITH will be, we will need to determine which tier the eligible activity falls into and the location of its operations. So I
Okay.
hope that answers that question.
Okay, so we hope you have answered that. We also have one question, Attorney Eman, for you from Kim Umnas. Question is, for a BPO firm, 100% export, which started commercial operations last year, how does the BOI define a new project?
Yeah. So although the CREATE law or the BOI and law did not expressly define what is new and expansion project, the IRR of RA 7916 states that new projects would refer to new activities distinct from their registered operations and may qualify as new projects subject to the setting up of new separate books. So in short, it should be distinct from the current activity registered.
Okay.
So expansion project, on the other hand, refers to modernization or rehabilitation, which, to be registrable, may or may not result in the increase, but in any case, subject to the following conditions. Number one, phases and stages of production sought to be modernized, rehabilitated must be identified. Second, it must be result in any of the following. Number one, substantial reduction of production costs and significant increase in production efficiency, including debottlenecking, meaningful upgrading of product quality, or keeping abreast with the state of the art in the production of the registered product. Ultimately, however, the criteria and conditions are up to the determination of the investment promotions agency. So yes, I hope the questions are answered.
Yeah. Actually, I think that's the concern of already existing company if they want a new project and they want to get those tax holidays. Thank you, Attorney Eman. We actually have here a few questions for our tax lawyers, Attorney Mau and Attorney Danny. We have here a question from anonymous attendee as well. What if the LOA was received by the company's auditor? Is the LOA valid?
Hi, with regards to these, I see two questions, and I believe that it can be answered in one go because it pertains
Okay.
to one issue. So,
Okay. So the next question that comes with that one is with regards to the communication. BIR should communicate directly to the company, yes or not BIR or the auditor of the company?
So for one, as explained in and also in my slides, a personal service may be affected to the taxpayer or to his duly authorized representative or duly accredited tax agent. So, well, it's arguable that maybe the auditor is probably the person in charge, but but of course, an argument may be made on the other side. But if such auditor is clothed with the special power of attorney to deal with assessments, then an LOA received by the such auditor and any communication made by the BIR to such auditor may be deemed as communication to the company. So, with regard to the first question, is the LOA valid? Well, there may be improper service, but if let's say that the 30-day period has lapsed, the BIR may still opt to revalidate it. So it is not completely void. So it's not yet completely void at that point, but it is something to consider if such auditor is not really authorized to receive it. Well, well, it may be argued that the LOA received by such auditor is not the proper service to speak of. Maybe Attorney Danny may also have insights on this.
Yes, so just to add to Attorney Mau's answer, with regard to the communication and receipt of the LOA, if it was valid, I do agree. In these instances, it's best to check if the auditor or whoever received the LOA on behalf of the company or whoever is communicating on behalf of the company should have a special power of attorney or at least a secretary's certificate, noting that that person is specifically authorized to deal with the BIR specifically for this LOA for a certain year.
Okay. Okay, so actually that's all the questions we just got right now. So if you have any question, you could just send us an email. We'll try to answer it. And we're actually on the last part of the engagement of this event. Just in case you will need any assistance for your PEZA and BOI application, you could reach out to InCorp Philippines. We'll be happy to assist you with your application with PEZA and BOI. And if you have any existing LOA that you need help with, so that you could try to reduce the assessment that the BIR balloon with you, you could reach out to Carpo Law Associates. They'll be happy to help you with that. Carpo Law Associates actually handle a lot of BIR laws right now, so you'd been in good hands if you hire them. And might as well with InCorp Philippines, we've been assisting opening companies here in the Philippines for 16 years already, and we've assisted BOI and PEZA registrations on top of their business registrations. So that sums up the webinar. My name is Sherwin Urbano. I'm the business growth head in InCorp Philippines. Just in case you need anything related to partnership or networking with our company, just reach out to me. I'll be happy to help and schedule a call with you. So once again, thank you for our speakers, Attorney Emman, Attorney Danny, Attorney Mao, and with our back support marketing team's been doing all this campaign. Really appreciate your help. And thank you again for the attendees. We hope that you've learned something from this webinar, and we're looking forward to see you again on our next event. Thanks, everyone.
Thank you, everyone.
Thank you.